before some of the UK's strictest censorship laws in living memory have come into effect, there are already calls to make them even more draconian.
So, the thing is, this is the thing, right? Even when they enact law, right? Even if they've enacted it and put it through, it just because the government have put it through doesn't mean to say that they can do it or that it's right. I mean, just look at the repeal of some of the Magna Carta that Elizabeth did in 1967 with the Criminal Law Act, right? She can't do that because they're still using those laws. Those laws have been repealed, like the Lord's privileges from the Magna Carta, not the 1688 Bill of Rights ones, but they're still using them as if they're still in effect. So they've actually repealed law that they're still pretending exists, and they're still claiming to use it now because it's for them. When it's for them and they want to use it, they're pretending they're ignoring that they've even repealed it, right? And then for us, the opposite of that is that they're enacting laws that they can't actually enact. Now, the thing is, they're talking about certain laws coming into effect and so forth. You've got this thing called incompatibility with convention rights. So in law, you can have laws are meant to be compatible and it's all meant to work and fit together. You'll find that the Criminal Law Act, 1967, that repealed from the Magna Carta can't possibly be compatible with the opening of Parliament because Parliament can't open because they repealed it. So that's incompatibility there. It's incompatibility with the convention right because they're opening Parliament with all of the ancient rights and privileges. Okay, all of the ancient rights and privileges, all of them. Right, but it can't be compatible with the repeals because there aren't all the ancient rights and privileges. So that's an example of incompatibility because that's an incompatibility because they're claiming it's still in effect and they can still use it when they've claimed they've removed it or repealed it, right? And then the opposite of that, the Criminal Damage Act 1971. That act is compatible because it says that it doesn't matter what, it doesn't go into any of the particulars of what you're doing. In fact, it covers all risks of danger or damage, all of them. Any damage or danger to the public or risk of it, right? All damages. It says that if you're using a right, privilege or interest, you're not going to be defending the charge. So they won't even be able to put the evidence or look at evidence and so forth because you're not defending the charge or proving what you did or didn't do. Because the privilege of Parliament is a different jurisdiction to the criminal courts anyway. That's an example of compatibility. So the 1971 Criminal Damage Act is an example of compatibility. Another example of compatibility is the Town and Country Planning Act, right? Because you've got your classes where you can use the enactment and then you don't need permissions to write or do anything because you can't be prosecuted for any of this surface damage. The problem is that the police have been prosecuting illegally for criminal damages when your rights apply in the Criminal Damage Act anyway, and it's not even criminal damage. It's not to be construed as being incorporated into the fabric of a building. When you put a notice on the surface of something, it's because it's defacement anyway. Even if you're not using a right, it's still defacement and not damage. All this is those are examples of compatibility when your rights remove all liability for these offences, right? Now, the Public Order Act 2023, in these new bills, policing crime and sentencing bill, whatever, that Sunak and Patel and Braverman and the government under Sunak's put through, and that they're threatening us with at the moment. They're making some arrests at the moment. A guy was arrested in Bristol for apparently shouting at a police dog or in public at protests, right? Free speech If he was shouting, if it was all verbal, all of your speech in matters of church, state and law in public are covered under the 1688 Bill of Rights. Free speech in matters that are addressed and put to Parliament in remonstrations. That is protected. Now, the Public Order Bill, right, in that act, it doesn't differ. It's trying to pretend or make it look like that there aren't any rights or privileges and that they're not applying them, right? When there are. The problem is that most public remonstrations or demonstrations are over matters of church, state and law. Most public, what you call a demonstration or a protest, is usually over political matters of church, state and law, right? Which is covered it's all explained in the 1661 Tumultuous Petitioning Act. Those activities have got privileges on them and they can't be criminalised. Now, what the public order, this new public order bill and so forth are doing is they're trying to create offences where you can be arrested or create them for things that are likely to be or most likely to be covered by privileges. So you can't be criminally liable. Some people won't be covered by privileges, okay? Just like random yobs who don't have a cause, or, I don't know, maybe if there's a marathon, even if the road's closed for a marathon and they're running around the marathon and all the people from the marathon start shouting at people, you know, or whatever. I mean, the thing is, when cyclists go past, everyone's shouting and jeering and cheering anyway, aren't they? You know, all the cyclists, whether it's positive or negative or whatever, or, you know, if people who are engaged in a sporting activity started, hurling abuse at people, they haven't got a political cause. But most of these public demonstrations and remonstrations are matters of church, state and law. And you can't enact a law because this is the thing. It's not compatible with the existing laws and rights. Because the existing laws and rights are that you can't be criminally liable, which is why it's enacted into the Criminal Damage Act. But the police aren't even doing that properly anyway. So what these MPs have been doing is creating some legislation which is not compatible with certain charges. This public order bill, right? If you're not engaged in matters of church, state and law, then it is compatible, if you start hurling abuse at people and doing, disorder when it's not under matters of church, state and law. But what they cunningly know is that most of these protests or actions are highly likely, the whole point in them is over matters of church, state and law. Now, if you're being prosecuted, like that guy in Bristol the other day who was apparently shouting at a police dog or whatever, but it was a remonstration over matters of church, state and law, it was an immigration protest, right? The correct method, well, you have got privileges of Parliament, but the thing is, this is important. This is really important. The Criminal Damage Act itself is compatible, right? There's nothing wrong with the Criminal Damage Act or the Town and Country Planning Act, right? They're compatible with the rights, but the police are misusing the law. The police and Max Hill, the Director of Public Prosecutions, are abusing the law. They're falsifying evidence and trying to get charges through under criminal damage when it is defacement. They're even trying to prove it's criminal damage. It clearly is anything that is on the surface of something is not to be, and it's to advertise something is not regarded as incorporated into the fabric of the building. So it's not identified as damage. It's identified as defacement anyway. And then, on top of that, there's compatibility with the 1688 Bill of Rights that you don't need permission and it's not even criminally prosecutable anyway. So you've got multiple compatibilities. The problem is the police either don't know that law or understand it, or they're just committing fraud. That they're bringing charges under a Criminal Damage Act when it's the wrong act with Angela Ditchfield. But Max Hill has even been awarded a knighthood, right? Which is honours, which is terrible. So that's the police's fault. But you don't claim incompatibility with the convention, right? Because the acts they're using is compatible. All of the acts they're using, but they're not. There's a defect in proceedings. They're falsifying evidence. They're committing fraudulent charges, and professional negligence. And it's a perversion of the course of justice, and it's an abuse of process. All those things, right? So that's actually the police. But with the Public Order Act, the actual act itself, it can be compatible if the police were only prosecuting people who weren't engaged in matters of church, state and law to the government. You know, like people who are doing recreational things and start creating public disorder, or business, someone, you know, if there's some kind of business promotion in public and then they start causing disorder. But the Priti Patel, mainly, I'm going to blame Priti Patel, really. I know she's one of the main protagonists behind this act, is that they know that they wanted really to try and stop people who are protesting on matters of church, state and law, but they can't, because the statute law says that they can't legislate against that. And when they've made this act, if they don't use it against people who are engaged in matters of church, state and law, if there are public disorders under that act which aren't matters of church, state and law, it is compatible. But they really, they designed it with protests in mind, and when it's used against matters of church and state and law, the act itself is compatible against these actions which are already using certain particular rights. So we've got a incompatibility with a convention right. Now, there's a special declaration process within the criminal procedure rules, including the new ones, 2020. It says that if you want to declare an incompatibility with a convention right, you do it through a special process, and you've got to enter the declaration, right? And that's what we need to be doing, which basically means you're challenging the act of law. You're challenging the act because the act is not compatible, and it's not just the police misusing it. They actually legislated it so there is not compatibility unless they admit that, you know, this is the thing with proving the rights basis as well. You know, like with the Stop ULEZ cases, because the Stop ULEZ cases, everything is compatible, but the rights aren't being recognised properly. Once you start getting the rights recognised properly for like the Stop ULEZ campaigns, because under the acts that are compatible, right? Like when you can use the rights, privilege and interest, then when you get to these other acts, you say, well, this is a model for it that we've used. The police aren't doing it correct in the Criminal Damage Act, and they're not doing it correct with the Town and Country Planning Act. And Max Hill is a main protagonist. He's been given honours. They tried to con us. They've tried to con us and cheat us from probably 2019. Max Hill's been given honours for it, unfortunately, but yet he's a criminal. And this is why we're in this position now, because it wasn't proved and validated and recognised properly and understood properly previously. So when you get to tackling it now, you've got a bit of a mess, because once it's properly understood, then you can say, just a minute, we've been doing this is the correct way to do this through the Criminal Damage Act, and this is the correct way to do it through the Town and Country Planning Act. So when we get to the Public Order Act, then it starts ringing alarm bells, and you're like, just a minute, this is not compatible with that convention right. But the problem is the police haven't been doing it properly anyway. Now, it's true that the police choose not to prosecute certain people because they know they've got rights, but the police have been doing quite a lot of illegal actions and unlawful prosecutions through abusing abusive processes and so forth. And then, therefore, a lot of people don't actually properly understand it. And there's a lack of confidence. You need confidence in protests as well. Well, people have definitely got confidence because they're going out and doing it. But, so with this public order bill and these new policing bills and so forth, when it comes to public demonstrations, the government have actually made incompatibility. And I want to show a clip from this. Where's that?
Looking at the.
So let me get to this bit when that woman, this woman, right?
Speech. Force us to hand over ID to access social media sites.
If companies fail to comply with the law, fail to protect the users that they're responsible for, the regulator Ofcom will have the power to fine, so platforms must keep people safe online.
Well, what about Nigel Farage? They're not taking any action against Farage. They're completely ignoring the law.
The government even tried to introduce provisions around lawful speech, which they deemed harmful to adults. This would have compelled platforms to identify these categories of so-called harmful speech and demonstrate that they were tackling it on their sites. Thankfully, after years of campaigning, the censorial, legal but harmful speech powers were dropped from the bill.
Why take out harmful but not illegal? Because...
Right. This is it now. This is the part I wanted to get to, and I've been talking for 17 minutes, right? Right, we're at 2 minutes 47 in this other video. 2 minutes 47.
Years of campaigning, the censorial, legal but harmful speech powers were dropped from the bill.
Why take out harmful but not illegal?
Because it's incompatibility with a convention right. That's why. Why take it out? Because you can't do it. And even if you have done it, you've created incompatibility. That's why. But let's listen to what her answer is.
Because it had very, very concerning impact potentially on free speech. There are
what? Concerning impact on free speech? If you did it, it wouldn't have effect. If you did it, it wouldn't have effect. Because you can't do it because of the existing law. It's going to have an effect on free speech. What free speech? Oh, the free speech that is granted in the convention rights, which says that you can't take away this right. It's not possible in law. Oh, well, we're just dabbling with it. We're just dicing with it. We're just deciding. We're just tossing up. Oh, shall we take away their free speech? Oh, let's deliberate what we'll put into this act. How far shall we go? Oh, well, we decided it wouldn't be fair to legislate against that. If we could, ha 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 ha. Oh, we decided that we might be impacting people's free speech, which exists protected in law, prevents us from impacting it. We're the ones with the power. We came to that decision. We thought about it and we thought, shall we take away more of their free speech with legislation? No. The law didn't stop you from doing it, lady. The law didn't stop you from doing it, did it? The actual Bill of Rights itself. No, that didn't stop you from doing it. No, we'll decide how much of this we're going to chip away at. No, how about none of it? None of it. It's not compatible. This is the problem. In fact, the Tumultuous Petitioning Act after 1689... After the 1688 Bill of Rights was made, which is completely, totally compatible with Magna Carta, the 1688 Bill of Rights actually made parts of the Tumultuous Petitioning Act incompatible with that new right. And to be honest, the 1661 Tumultuous Petitioning Act, in modern standards, that's not compatible with Magna Carta, because that took away Magna Carta rights, and rather than the judgment of your peers and the oath of the petition, they started putting restrictions on then. That wasn't really compatible with Magna Carta, but for sure, when they made the 1688 Bill of Rights, that's one of the reasons why they made it. And the 1688 Bill of Rights, really, the Tumultuous Petitioning Act already, which was incompatible with that Magna Carta clause, it was definitely incompatible with the 1688 Bill of Rights, but the Tumultuous Petitioning Act's been repealed now anyway. So these politicians are joke. It's like they're joking. Oh yeah, we've got a little bit of morals. We've got some morals. We could legislate absolutely anything we wanted. We can do anything in law. But we've come to the conclusion that we think it wouldn't be fair. Based on what? Based on the fact that it says you can't do it.
And the consequences associated with it. It was really the anchor that was preventing.
Oh, the anchor. Now we go. He is the anchor.
This bill from getting off the ground. It was a creation of a quasi.
Oh, right, here we go. Oh, no, she's anchored. Now she's anchored. Where's Priti Patel's anchor? The anchor is that if it's matters of church, state and law, that Public Order Act can't be used. So why are the police prosecuting people with it? Why aren't they just prosecuting, people who are going on or jogging? Or doing some kind of Coca-Cola event in the middle of the centre of London. Oh, there's a Coca-Cola event in the middle of the centre of London, and everyone's starting to create disorder. This is not matters of church, state, or law. This is the thing. These politicians know. The fact is that public order bill, it actually does not apply to the protests or political ones, and the police are prosecuting. And, it's to be expected. These police don't have any regard or respect for the law at all. They don't even understand the Criminal Damage Act, and they don't even know about the town and country planning, because the police don't normally get involved in town and country planning. It's usually the council. Right? And usually defacement is dealt with by fines, right? So it's just not in the police's normal repertoire. And the reason is that it's not criminal damage. But the police, they want to make it their repertoire. They be calling criminal damage. Well, if we get it through a court, then it must be. We'll try the case. Try reading is not to be regarded as incorporated into the fabric of the building. It's because it's on the surface, right? It's an advertisement. If we don't get abuse of process against these police forces, we're not having enough actions against the police. It's not enough to just fight each case by case. The force, right, need to be told, you will not bring criminal damage charges on surface writing, right? Because you can't. Because it's not incorporated into the fabric of the building. It's an advertisement, But particularly when it's one that doesn't need permission, and it's for political purposes and using a convention, right? Which says that you can't be criminally liable. Only civilly. It's not only civil liability. It's not for the police to get involved. If the business or company want to take action, civil action against the political campaign group, then they can do, but not criminal. This is the thing. We need some of these incompatibility declarations put through with some of these bills. And all the government have done is they know that, they're anchored and they're not supposed to do it, but they're fighting their own campaign, they're fighting their own fight. But the problem is that these laws were enacted to facilitate and enable people to act and complain against certain companies and maybe even businesses as well, without being criminally liable, and they can sort their disputes out in the civil courts, particularly when it's matters of church, state and law, because, some of these businesses might be, they're all Companies House licensed, they might be polluting us all, or, harming the environment, which is what the argument is.
Illegal category between illegal and legal. That's not what a government should be doing. It's confusing.
Well, there is no illegal, because you can't be you're not criminally liable. You're not criminally liable, and certainly for not shouting at a dog or shouting at people, voicing while it's on matters of church and state of law. It's just not.
Using it would create a different kind of set of rules online to offer.
No, you can't create a different set of rules for those subjects, for those matters. You can't create them. You can't create different sets of rules. It covers them. Well, it covers the subject, not the method or mode, because the method and mode, right? Land, sea, or air. Land, sea, or air, right? Land, sea, or air. English, French, or Dutch, right? Matters of church, state, and law in English. Matters of church, state, and law in Dutch. Matters of church, state, and law in French. Matters of church, state, and law by land. Matters of church, state, and law by air. Matters of church, state, and law by sea. You're trying to remove the subject, lady. The subject... The right of the subject. You're trying to say it's not the subject. And that's what Priti Patel has done in this public order bill. She's pretending that it's not a subject of church, state and law, because this woman doesn't even have a faith in church. She's not a Christian. She doesn't have faith in church because she's not of that religion, right? The subject... You can't change the subject when it's the subject. And what the police are doing when there's a protest about illegal foreign immigration, right? They're trying to say, pretend it's not that subject. They're trying to pretend it is not the subject. And that is a lie. And when you even go into court, they don't even want them to talk about the environment. They're not allowed to mention it. Well, why am I going to claim the right? This is a protest about the environment. That's how you recognise. How do you recognise it's a political protest about the environment? This is the thing with Roger Hallam, because he's the subject. Now, if you can't mention the subject in court when you're being illegally prosecuted because the mention of the subject would have the right recognised, so you can't be prosecuted, what Priti Patel is trying to do from that bill is erase the subject. It's like R.E.M., that's me in the corner, losing my religion. I don't know why you do it. Oh no, I've said too much. I haven't said enough. That's Roger Hallam. That's what Roger Hallam should be singing in prison now. Oh no, I said too much. I haven't said enough. That's me in the corner. That's me in the spotlight. Losing my confession, my religion. This is it. And that's Priti Patel. She is in ignorance of the subject and trying to pretend there is no subject, which cannot be separated from the right and is anchored to it. And this is why this woman is not fit for purpose. She's not fit for office. All of the Tories, they've lost. Most of them have lost the seats anyway.
Line in the legal sphere.
Yet now there are calls from some of Labour's most high-profile politicians to revisit this census charter.
So that's it. We've got crime. It's politicians, and what they're doing is they are making orders which are against the Great Charter. They're actually making bills and orders which are against the Great Charter. And what they're also doing is they're trying to confuse people so they don't really know what is on the menu, right? Because really that act can apply. They can use that act when it's not matters of church, state and law. But the police have got it now, and it's made to mislead people. It's made to make it look like they have and can use it in public protests over matters of church, state and law, and they can't. It's not compatible with them. It's only compatible with commercial, business and leisure, public disorder. That's the problem. And the police chief, if the police chief continues to prosecute, it's perverting the course of justice. And these people are honoured. They've got honours. So as Max Hill, they need to lose. There's a special committee for removing honours. Just because they're fighting a fight on behalf of, Keir Starmer and the realm, the Knights of the Realm, but they're doing it illegally. They're forfeiting, and this is when other rights come into effect, like the right to defend yourself with arms when a employed force is breaking the law. So you've immediately got, do I need to send this into 77th Brigade? Do I need to send this into 77th Battalion? Right? Do I need to send this into MI5, into the police? The police are breaking the law, they're arresting people illegally, and you are allowed to arm yourself and defend against these police forces. I'm not lying about that. I swear on Almighty God, it is the truth, the whole truth, and nothing but the truth. The police are breaking the public order bill and acts, the new 2023 ones. They're arresting people on matters of church, state and law, which is incompatible with a convention right. And those protesters have got a legal right to arm themselves and defend themselves against the police force. They can use any amount of speech verbally, right, to do that. And to express their opinions in those matters to anyone, right? And if 77th Battalion have got a problem with that, then that's not my problem. The police are the ones who are terrorising us. The police are the ones who are breaking the law, right? Attorney General claims that he's going to enforce the rule of law. I'll believe it when I see it, right? People are getting arrested in Bristol for literally shouting at police dogs, as if a police dog can't understand that it's a protest about immigration addressed to the government. Well, we've got problems. Why can't they just... right? Do the law properly. But yeah, we've got Max Hill with knighthoods. We've probably got people, Emma Arbuff, not on her husband, in secret services. But the problem is, we've got criminals with honours in this government. We've got honoured and decorated people with honours, and no one will take criminal action against them because they will lose their honours and be stripped of honours, and it makes King Charles III and his establishment look bad, like Jimmy Savile. It makes Sir Mark Rowley look bad, like Jimmy Savile. It makes Sir Keir Starmer look bad, like Jimmy Savile. It makes Sir Max Hill KC look bad by Jimmy Savile, yet it is an abuse of process in law. It is a perversion of the course of justice in law of this realm. It is subverting the freedom and liberties of the realm under the 1688 bill. Who can do this crime? Evil judges, magistrates, councillors, sheriffs. This is the problem, right? So we need criminal action against honoured, decorated individuals. And at the moment, it's not going to happen. Why? Because honoured, decorated individuals have been put in charge of these services. The police, the Crown Prosecution Service, Secret Services, 77th Brigade Battalion, right? and I'm sat here speaking to my mobile phone, yet these are the people who are perverting the course of justice in England, right, against the people, and members of Parliament are making incompatible legislation, and they can be brought to justice through the Supreme Court. Why aren't Crown prosecutors taking them to the Supreme Court and declaring incompatibility of a convention, right? Because the Crown Prosecution Service is happy with the new legislation. It likes it because it's helping facilitate further perversions of justice, further abuses of process. So we've got a problem here. Where are the honoured, decorated people who are acting lawfully within the law, upholding the law? I don't see any of them. Where are they? This is what we're looking for. This is what we're looking for. Where are the honoured, decorated persons who are acting within the law, impartially, who are going to bring to justice other criminally operating people who are decorated? This is the problem, right? They won't act against them. I don't know if they're sworn in, if they've got Privy Council, odd oaths, weird perverted oaths, they can see no wrong, do no wrong, imagine no wrong. This is the problem. So this is why these rights exist and are created when a force is led and employed by Sir Mark Rowley, by Sir Max Hill, by Sir Keir Starmer, why you have the right to defend yourself against these forces which are breaking the law and perverting the course of justice. Why isn't Priti Patel in the Tower of London? Why isn't she prosecuted by the Supreme Court of England in front of the three lords in a court by her equals for making incompatible legislation? Oh, illegal prosecutions by the King's Bench for matters decidable, debatable in Parliament. Well, that's another trick of Gordon Brown's, isn't it? Maybe we should have him in front of the Judicial Committee of the Privy Council. That's in Parliament, right? We need MPs in prison. We need the MPs in prison for things they're doing in Parliament illegally, incompatibility with convention rights. This is the problem. If Rowley continues to break the law, something's going to have to be done. If it comes to divine intervention, which Priti Patel doesn't believe in because she doesn't have any religious faith in the religion of this country, do we need to write to, Rome Williams? Do we need to write to Justin Welby? Who is going to actually make these Knight Commanders of the Bath order, right? Who is going to make them obey the law? And who is going to hold them responsible for criminal activity? Because at the moment, no one's up to the challenge, because no one seems to be taking... You can prosecute Knights of the Realm. Knights of the Realm can be criminally prosecuted, right? And I couldn't give a fuck what honours they've got. They're dishonourable. There is no honour. There is no honour. What they're doing is, Max Hill has been rewarded for perverting the course of justice. Max Hill has been decorated and given honours for perverting the course of justice against Angela Ditchfield because he's a criminal, right? And he needs prosecuting in a court, and he needs his honours removing from him, right? That's what needs to be done. And if no one has got enough money to do it, the Crown Prosecution Service aren't going to do it because he was leading them, right? Well, we've got criminals. We've got constitutional corruption. We've got institutionalised corruption. That's the problem.